Debbie Hines is with us, our favorite legal commentator, a trial lawyer, former prosecutor, legal political commentator over at LegalSpeaks.com. Hey, Debbie, welcome.
Hi, Tom.
Or welcome.
Nice to be back. Yes.
Welcome back, I should say. I'm not sure if we have your video. I think we've lost some of our internet connection.
Yeah, we lost the internet connection. Yeah. I'm up, but
yeah, that's fine. You know, just having your voice is fine, and we've got a nice picture of you that we'll get and throw it up on the screen. A couple things that I wanted to go through with you. The first is stand your ground. This is the top of MediaMatters.org right now, and they say that the jury instructions that would have been given prior to the Stand Your Ground law being passed would have read, the defendant cannot justify the use of force likely to cause death or great bodily harm unless he used every reasonable means within his power and consistent with his own safety to avoid the danger before resorting to that force. The fact that the defendant was wrongfully attacked cannot justify his use of force likely to cause death or great bodily harm if by retreating he could have avoided the need to use that force. That was the law prior to the passage of Stand Your Ground. Since Stand Your Ground, now the jury instruction is, and I quote from the judge in this case, Judge Nelson, if George Zimmerman was not engaged in an unlawful activity and was attacked in any place where he had a right to be, he had no duty to retreat, and he had the right to stand his ground and meet force with force, including deadly force, if he reasonably believed it was necessary to do so to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. Virtually all of that coming from the Stand Your Ground law. And yet, we get these bozos like the folks over on CNN who I can't play it now because I've lost my internet, who are saying, oh, you know, there was no Stand Your Ground part to this thing. Debbie?
Yes, I'm here.
So I'm curious your thoughts on that.
You know, Tom, in the final analysis, with this jury, this case, I don't really know how much difference it would have made. And that's just my honest opinion about the whole thing. Okay. Because there was enough there, notwithstanding the jury instructions, to, you know, convict him, because there still was the if he's the, and I'm not looking at the jury instructions, but there still is a component that if you are the aggressor, that's when you have the duty to reasonably retreat if you were the aggressor, such as he were. So that's not to stand your ground. That's their traditional self-defense instruction.
Well, and this leads to the second piece, and this is this piece by Alifair Burke over at Huffington Post. She's a criminal defense lawyer and the daughter of James Lee Burke, the novelist, and she writes that the initial aggressor instruction, where if you're the initial aggressor, you're prevented from using a self-defense defense, and the state wanted that instruction read to the jury that they could not consider a self-defense defense if Zimmerman was determined to be the initial aggressor. And Don West said, and I'm quoting from the transcript, well, let me point out, Judge, as a matter of law, someone following somebody on foot or by car is not against the law. That cannot be considered provocation under the law. If force means physical force or the threat of physical force, it would be error, and he said it very loudly, and frankly promoting miscarriage of justice if the state were allow that to be argued to the jury. And then Judge Nelson said, the defense does not want to give the initial aggressor exemption. The state does want to give it. This court is not going to give it. And Alifair Burke says, watch how West emphasized the word error. Error is a word used to invoke fear in trial court judges that they will be reversed on appeal. Coupled with his previous phrase as a matter of law, West was suggesting to the court that delivery of an aggressor exemption would be the kind of decision that would lead to reversal on appeal. And he actually quoted an appeals court case, but he quoted the case wrong. Thoughts on that?
Well, I mean, Judge Nelson knows the law. She's a trial attorney. I don't think she has any fear of anything that the defense attorney or the prosecution would have said to her. So I don't think that that's basically the issue. And yes, judges do routinely, pro or against you, make rulings that are not correct as we feel that they're correct on the jury instructions. But I just still think that that's just such a finite That's just such a finite nuance. I mean, I know the jury had to find, the verdict in accordance with the law, but at the end of the day, I just don't think that this jury would have found a way to find George Zimmerman not guilty, because there was enough there, even under the instructions, to find him guilty. I mean, the jury basically disregarded all of the testimony of everyone, relied on the testimony of John Good, who's the only witness who said that he saw George Zimmerman on the top, and then, of course, I don't know how much they used of George Zimmerman's testimony, but they had to disregard a lot of witnesses to come to the conclusion that they came to.
Yeah, especially Rachel Gentile. So
Exactly.
By this jury, are you saying 5 white women and a Hispanic woman?
I'm saying a jury
or a jury lacking any African-American members?
Well, I'm going to be more specific, because I always feel that with a jury, that's why we take so much time to select a jury, that the devil is in the details. So let me be clear. There were 2 white women on the jury that the state struck. For whatever reason, I'm not privy to know why, but they struck them. So we can assume that the state would have thought that those 2 women would not have been favorable for them. But once the defense objected to it on what's known as a Batson challenge, where you have to come up with some race-neutral reason for striking them, they were allowed on the jury. Okay, you got 6. You got 2 that the state didn't want. And then you have another juror who basically says that when she was asked about the protest in Sanford, she referred to the peaceful protest as rioting. I think that says a lot about what she feels about the case. So when I'm saying these jurors, I'm talking about these specific jurors that were on this particular
So you're
case.
saying that there's clear evidence of at least one of the jurors going in prejudiced to begin with, and 2 others in all probability?
Correct. 2 that the prosecution wanted stricken, and based on all the information that they had about them, there's a reason why they wanted them stricken.
Remarkable. Debbie Hines, legalspeaks.com. You can read Debbie's blog or her comments over there. Debbie, you're brilliant. Thank you for dropping by.
Thank you, Tom. Glad to be here.
Always
Thank
great
you.
talking with you. I'll see you on TV.